In 2016, New Mexico voters overwhelmingly passed a constitutional amendment that proposed to give judges the power to jail people accused but not convicted of crime, and also that reinforced or retained the rights of non-dangerous defendants who aren't a flight risk to be free while they await trial. In the years since, the justice system has been debating the effectiveness of the rules created to administer those principles. You've certainly seen it on the news and in the papers, prosecutors and police bemoaning the release of people who reoffend, and defense attorneys and the court system saying that the new system, while not perfect, is largely working and, vitally, it's constitutional. Our guest is Artie Pepin. He's the director of the Administrative Office of the Courts. Artie, thanks for being here.
My pleasure to be here.
More than a few people see this as a tough-on-crime issue, something akin to detached judges hewing too closely to some constitutional principle that just doesn't really apply to real life. What underpins your view?
Well, the courts don't really have a view on whether we should be tough on crime or not. The courts administer the law and the Constitution. But I think the essential principle that courts are dedicated to is fairness in the justice system. Without favoring one side or the other, we have a system that has the ways in which people go through the criminal justice system from arrest to conviction. And we have a strong constitutional principle that says we punish people, we put them in jail or prison after they've been convicted. And in the pretrial context, which is what we're talking about, it should be an unusual, difficult thing to put someone in jail before they get convicted. And that's the system we have, and that's the one that we think is working. Of course, we can improve on it, and I'm sure we'll talk about ways in which we might improve on it. But we're much better off than we were before the voters, I think wisely, adopted the constitutional amendment in 2016.
What's the universe of people we're talking about that this applies to? You've sort of touched on it, but let's define that.
So most of the data we have on Bernalillo County, anyway, are felons. We're talking about people arrested for felonies. There's been about 20,000 felony arrests since the constitutional amendment was put in place. About 10,000 of those cases had resolved by early 2020, so that's what the study that you mentioned looks at, those 10,000 cases.
Well, how is the court handling this right now? What system are they using to figure out who's dangerous, who isn't, who can go free, and who should stay in jail?
So focusing on Bernalillo County, you have a pretrial division over at the 2nd Judicial District, your district court here. And when a judge releases someone pretrial, which is what happens with almost everybody, most people are released. Of those 10,000 people were all released. The court sets conditions on their release, and that is from telling you your court date and telling you to come back next month, 2 months, whenever your next court date is, and otherwise leaving you alone, to having you contact pretrial services, maybe doing drug testing, contacting your employer, make sure you're going to work, all the way up to electronic monitoring or ankle monitoring that's used. And then when the prosecutor brings a motion for detention, the judge can grant that motion, and then you're in detention. I think it's important for people to know that we're talking about people who have been arrested and charged, and they'll have a trial, or they'll plead guilty, or their case will be dismissed eventually. We're talking about the period between the charging and the resolution. Whether that resolution is the case is dismissed and nothing happens, or they're acquitted, or they're convicted and then they get sentenced to jail or prison. We're talking about those people in that in-between period. And it's important to note that I think that the Constitution presumes those people are innocent, but the constitutional amendment gives an exception for the court to keep some people in jail. I think it's also very important to remember the court can't do that on its own. The only time the Constitution allows the court to put someone in jail before they go to trial or the case gets resolved is if the prosecutor asks for the person to be detained, and then shows that really nothing short of putting them in jail before they get convicted will protect the public. And that's a difficult standard, but that's the standard that is in the Constitution, and it enforces the presumption of innocence. But 2,000 times since 2017 in Bernalillo County, the courts have agreed with the motion by the prosecutor and kept those people in jail before their case got resolved.
Bernalillo County is where a lot of this takes place. As you said, it's the second judicial district. So for folks who are trying to figure that out, that's what we're talking about. You brought up the word presume. And as we read the papers and watch the nightly news, we hear this phrase, rebuttable presumption.
Yes.
Something that Raul Torres, the second judicial district attorney, has brought up, something the governor has brought up. It's not the presumption of innocence, it's the presumption that the crime of which you're accused is so serious that automatically you are kept in jail unless you can rebut that or you can prove that you're no danger to the community. Is part of the problem the courts face in talking about this that something like that might appear to be a sensible solution? Well, look, these folks are dangerous, murder is a serious crime, child abuse is a serious crime, you wouldn't debate any of that. No. But they're saying that the fact that you're accused of this means that you need to stay in jail until whenever that happens.
So the courts don't take a position on presumptions. That's something the legislature will determine. If they pass something the governor signs, obviously the courts will apply the law that the courts are given. What we try to do, we've been at this for 3 years now, and the Supreme Court has appointed commissions over the years, has gathered people together to talk about, here's what we're doing, here's what we've looked at the data, it shows us this. What do you suggest we do to make the system work better? Regarding presumptions, all that the courts ask of any change that we have adopted or of any change suggested by anybody in the whole criminal justice system is suggest practices that evidence shows will result in the kind of outcome we want to achieve, because it makes no sense to change the system if it's not going to make the system work better. We have an evidence-based risk assessment system that does a good job of identifying those who are lower risk and those who are higher risk. But these are only risks, and the judges are faced with being required to release everybody under some kind of conditions unless there's a motion, and then deciding in those motions if these are the people that should be essentially punished before they get convicted by being held in jail. And you know, the public is interested in those cases where there's failure. That is where people are arrested for a murder, armed robbery, you know, terrible crimes, and they were on release, and if the judge had a detention motion, they could have granted it. So while I don't say the numbers are good, I think it's a good place for us to start to try to get the numbers lower. If we'd had 10,000 people and 5,000 of them had been arrested for a new crime, that would be a lot more challenging system to make adjustments to than having 4.7% of the 10,475. And as we narrow it down to the ones arrested for violent crimes, a much smaller number. So if there's a way we can figure out how to find those people and keep them before they commit an offense, great. You know, the ones that there's not a detention motion on, the judges can't keep them in jail. They can put them on an ankle monitor and have them monitored, and we've recently made changes in how we do that to strengthen the public safety aspect. So we're always willing to make changes that are supported by evidence and that will help the system do a better job, respecting the fact that 99.9% of the people the courts did release didn't get arrested for a violent felony. In the world of predicting human behavior, that's not terrible. That's pretty good. You know, it's hard. It's very hard to be accurate 100% of the time. We would love to get that number to zero.
Sure.
That's our goal. We'll continue to try to change the system to get closer to the goal.
Sure. I feel like the most useful number there to talk about would be that 475, the people arrested for violent crimes.
Sure.
That's sort of what makes the headlines and that sort of thing.
And I think I appreciate that people look closely at the study. Let's talk about those 475 people. I already mentioned, you mentioned, 13 of them were arrested for a first-degree felony. People probably know first-degree felony, you can go to jail for 18 years or life, depending on the crime. Second-degree felony, 9 years. Third-degree, 6 years. Fourth-degree, 18 months. And then there are misdemeanors, up to 364 days in jail, and petty misdemeanors, 180 days. And I think it's important to note that around 87% of those people who got arrested for a violent offense were in the fourth-degree felony, the lowest level of felony, or misdemeanor or petty misdemeanor category. The arrests were for low-level felonies. So that can't involve crimes in which people suffered serious injury. Obviously, it doesn't involve murder and kidnapping and those kinds of things.
Okay.
So I think it's important to look at the numbers and say, all right, so there were about 50, a little less than 60 people who got arrested for a first or a second degree violent offense. I also should point out that we define violent offenses by agreement with the other members of the justice system. The district attorney, the public defender, and law enforcement were all involved in creating that list of crimes that we qualify as violent. And some are more violent or riskier than others. And so that's why the legislature grades them as first degree, second, third. So I don't want anyone to mistake the idea that I'm happy that the majority of that a large number of the 475 were arrested for a fourth degree felony, a misdemeanor, or a petty misdemeanor. But that's better than and less risky to the public safety than those who got arrested for first degree felonies and second degree felonies.
Okay. Just if we could take a final minute to talk about what's ahead for the legislative session.
Sure.
District attorneys, the governor, they've talked about, as I said, the rebuttable presumption change to what's going on. Is there anything that the courts have looked at that they would favor, any adjustments, changes, things like that?
Well, as I said, the courts have made changes to the system as we learn what works and what doesn't. As I said before, we support whatever evidence shows works to make people safer and to identify those people who present a greater risk. We think we know because we just got a study of 10,000 cases that validated the instrument we use. We know we have an instrument that helps us narrow down into those people who present lower risk and higher risk. And we believe judges have the tools to mitigate, to reduce the risk for those people who aren't detained. We don't require legislation to adopt overnight active monitoring of people on electronic monitoring, for instance. So we're doing that. It'll start very soon. The people are hired and they're being trained. I know that the district attorney and the governor have both come out in support of presumptions, and I think I said before, if there's evidence to show that they can help us identify dangerous people, great. I'm sure the legislature will look to evidence and try to do the right thing, and the courts will apply the law that we're given from the legislature.
Artie Pepin, Director of the Administrative Office of the Courts, thank you so much. We will ask you to stick around and talk a little bit more about this online, if you would.
Sure.
Thank you so much.